everyone, my name is Heather Huilitun. Welcome to another episode in Legalese Translator. Today, we're going to talk about the term contempt of court. Now, many of us already have a general understanding of what this term means. We know that when we go to court, we must follow the rules of the court and we must be on our best behavior. Otherwise, the judge might make an order against us. In this video, I'd like to get into a little bit more detail about contempt and how it plays out in practice. So joining me here today is civil litigator Heather Douglas. Hi, Heather.
Hi.
Thank you so much for being with us again, Heather. I was wondering if you could tell us the basics, first of all, behind the term contempt of court.
Yes. So there's two forms of contempt of court. There's the civil side, and then there's the criminal side. So the rules of civil procedure under Rule 60.11 set out contempt of court on the civil side. There's also corresponding criminal conviction that you can have that's found in the criminal code. The difference between the two is contempt of court criminally is a public, willful, deliberate defiance of the court. It is a challenge to the court's authority, and it compromises the ability of the court to administer justice. On the civil side, contempt of court generally happens when a party fails to comply with a court order. That action, that failure to abide by a court order could take on a criminal nature if it's done very publicly. So an example of a civil contempt of court would be a party's failure to abide by a court order to answer undertakings. That action could turn into criminal contempt if you start making that very public. Let's say you go on television and you start telling the world why you believe that the administration of justice is BS and you don't have to listen to it and you're not going to abide by the court order and you're challenging the jurisdiction. Well, now you're very public about your defiance. And once you get into that arena, now it's going to take on a criminal nature.
That's really amazing to know. So you're telling me that even say in a civil lawsuit, in a civil trial, if somebody publicly is defiant, they can be found in criminal contempt.
Yes, the rules allow the court to make several different orders as a result of a finding that someone is in contempt of court. So 60.11, under that rule, one of the actions the court could take is imprisonment. Wow. It could also be a fine. It can be costs against a party. It could also be an order that someone take a particular action or abstain from an action.
Has this happened often in your practice? Have you seen this happen a lot?
No, this is very uncommon for parties to bring motions to find a litigant in contempt of court. Additionally, it's not often that someone would be found to be in contempt of court criminally as well.